interestingly, having read the CRC's report, we the people want impeachment. We want some mechanism that can hold our parliamentarians and other public officials to account. Impeachment is one. Impeachment is a more legal process that would happen in Parliament itself.
The people of Jamaica rejects the new constitutional reform bill proposed by the new Senator, the Honorable Dr. Dana Morris Dixon, Office of the Prime Minister, due to the facts that are no impeachment law in the proposed constitution bill to hold members of Parliament for any wrongdoing while in public office.
But what was disappointing is that the CRC's report said that impeachment can be too problematic, because we've seen in other jurisdictions that impeachment has been used as a political ploy, has been exploited. And I want you to think on what you want as citizens.
Member at Town Hall meeting exposed PM Andrew Holness dictatorship within the Constitution reform.
In that regard, I want to refer to the actual Dr. Lloyd Barnett wrote a simplified book that anybody could understand. Thousands of copies were circulated so that people had a sense of what is in the Constitution and what needs to be done, ultimately leading to the Charter of Fundamental Rights and Freedoms. I conclude. The report of the current Constitutional Reform Committee of May 21, 2024, sisters and brothers, either ignores or rejects, in the context of grossly inadequate public education, grossly inadequate public consultation or explanation, they either ignore or reject these curbs on executive power, which our founding fathers, there were no women on that constitution-making committee, it's a point to note, which they said needed to be looked at in terms of the dictatorial powers of the Prime Minister. The dictatorial power of the Prime Minister remains, and with it, the inadequate ability of the people to hold the Prime Minister and the majority that he controls to account. This is completely unacceptable.
Within our first 100 days of government, we will start the legislative process to fix the date for general elections in Jamaica.
Prime Minister Andrew Holness broken promises.
So no government will be able to come and make false promises and hide the truth, trick you into voting for them, and then when them win, them throw on poison for you.
I read an article saying the government of Jamaica is seems to be changing its position. The position hasn't changed from day one. I was very clear. I'd said then as well that there would have to be differential treatment for persons who are vaccinated versus persons who are not. The government's position has not changed.
Within the first 100 days of our government, we will start the legislative process to institute impeachment proceedings in Parliament. This will add another layer of protection of the Parliament to ensure that only members of unquestioned integrity sit in the Parliament.
This is Mark Golding, President of the People's National Party, and I can tell you, I am not one of the illicit six, and my statutory declarations to the Integrity Commission have been certified and published for all years through to and including 2022, and my declaration for 2023 was filed in time by the March deadline in accordance with the law. God bless you all.
All ministers under the new Jamaica Labour Party government will be given a job letter. That job letter has a timeline of 2 years and 6 months with key performance targets which are agreed upon by the cabinet, focused on two things: economic growth and job creation. Within the first 100 days of government, we will start the legislative process to introduce term limits on the office of Prime Minister. At a convenient time within our new government, we will hold
a grand referendum on the CCJ, the Caribbean Court of Justice, as the final appellate court.
You make so much promise for us. Look how long you're in there. Nothing done. All for the COVID. You promise the people them $25,000. Nothing done. Huh? So what you expect me to do?
100 days. The fixed election date. Still I wait for the promise to fulfill. One broken promise after another. Laughable. As I say, none of your promise no fulfill yet, boss. So there you wait.
Andrew Wellness, January, him break him promise and nothing him say I'm gonna do for the next 100 days and all, now him not do nothing. Him not keep no promise and him say I'm the promise keeper. What a promise, January style.
Andrew, you need to do what you said from 2016. You say you're going to put it on paper. So anything you put on paper, the MP have to work with it. So you need to do it now. Because I feel like, say, when you do that, the MP will do them work. And we will see work done in the community.
Now welcome back to another Exclusive for Life. Now blessing goes out to all my viewers and all my subbies, all my well-wishers. Like, share and also subscribe if you haven't done so already. Coming up in today's topic and review.
Mark Golding launches broadside against the Integrity Commission, accusing the body of being slow and inefficient and not working in the public's interest. Integrity Commission official signals new corruption probe reports coming soon. During deliberations on several reports from the IC that had been tabled in Parliament, Chuck read from the minutes of a previous meeting, indicating that Craig Beresford, the Director of Information and Complaints, had intimated that the basis of the probe into the illicit six was a mismatch among purchases, expenditure, and income. However, Beresford quickly sought to set the record straight, indicating that he had been misquoted. According to Beresford, he was defining illicit enrichment in general terms as a mismatch between asset and income. The Director of Information and Complaints said he made no specific reference to the parliamentarians being investigated for illicit enrichment.
And if they were working efficiently and conducting their investigations on a timely basis, you would have a steady flow of newsworthy material coming to Parliament.
Dear Jamaicans, good morning. Anybody who is surprised by what looks like arson attack at Garden House last night obviously don't know Jamaican history. This is the JLP playbook. Dead on. This is what they did in the 70s, and if you were alive in the 70s, you would remember that they did a lot to create distractions with the help of the CIA when they thought they were going to lose the 1980 election. Not even 1980, they did it before the 76 election, which they lost, but they did a lot of distraction, right? And when they thought they were going to lose the 80 election, this is exactly what they did. They created distractions all over. So this is just coming out of them playbook to distract you, the ordinary Jamaican, from what is happening. The fact that they're meddling with the Constitution, that is the most important thing that you should think about, Jamaicans. They are meddling with your Constitution. So the things that they tried before that they couldn't get away with because we were protected by the Constitution, they are going to change the Constitution now to make sure, say, them can get exactly what they want. It's a 3-card trick, right? And you're not supposed to fall for it. We can't allow this government to do the things that they're doing and get away with it. There comes a time when we have to stand for something, or trust me, though I'm not going wishing we could have run left Jamaica when them labor right here done with Jamaica. I thank you. Have yourself a good day.
And I want you to think on what you want as citizens. For example, the matter of the Prime Minister having the power to call the election whenever he or she deems it most expedient for their political party, whether you want a fixed election date. And just to say that, having read the CRC's report, based on my understanding of their recommendation, is that rather than having a fixed election date that they deem would be too inflexible, the life of Parliament, which would end after a 5-year period, once the life of Parliament ends, within a 3-month period, the Prime Minister must call the election. I don't remember it specifying whether general election would, the local government election, sorry, would so apply. I'm just speaking from memory here, but that's one. Interestingly, having read the CRC's report, we the people want impeachment. We want some mechanism that can hold our parliamentarians and other public officials to account. Impeachment is one. Impeachment is a more legal process that would happen in Parliament itself. But what was disappointing is that the CRC's report said that impeachment can be too problematic, because we've seen in other jurisdictions that impeachment has been used as a political ploy, has been exploited. But the CRC did not even recommend or speak to the matter of the right to recall, where the power would be vested in we the people to say that if we have amassed a particular percentage of signatures in our constituencies, then you could remove a particular member of Parliament. It did not even acknowledge that. Before I get to our panelists, I just want to quickly summarize two critical aspects in the report that I want the panelists to speak to. We've been asking what type of president we want, non-executive or executive. An executive president is normally elected by the people, but where we're having this conversation of head of state versus the head of government, the executive president, those two duties are in one person. And there's danger in that, because sometimes if somebody is running up and down trying to get your vote on the political campaign, and then tomorrow you come talking about unifying us as a people, I don't know which hat you're wearing, whether you're wearing the political hat, your head of government hat, or you're wearing the hat of head of state. So that is why a lot of us say, let's focus on a non-executive president, which is what the CRC is recommending. But what is disappointing, having read the report again, the CRC simply states that the non-executive president will follow the Governor-General model. Now, for the average person who is reading that report, the question is, do you know the existing powers of the Governor-General? And do we simply want to replicate the existing powers of the Governor-General? Because you do have some important powers, but do we want to strengthen them? The CRC report did not give us the courtesy of outlining what those powers are and what powers need to be strengthened, and whether or not we need to say that this new non-executive president, even if you consult with the leader of the opposition, consult with the Prime Minister, you should be free to depart from whatever advice they may have given. These are the things that we need to be thinking about a little bit more. What are those powers that the non-executive president would have? Another concerning recommendation in that CRC report, remember now we have 21 senators. The 21 senators, 13 of which are appointed by the ruling political party. The remaining 8 are appointed by the opposition. Firstly, I think that the recommendation reinforces a two-party system a little bit too well. But that's another conversation we can have on electoral reform. But what is concerning is that there is a recommendation to increase the size of the Senate from 21 to 27. Why is there a concern? The ruling political party would now appoint 15. The opposition would appoint 9. And the non-executive president would appoint 3. Let's do the maths. 15, 9, and 3. That's how many? 27. Work with me now, you know. Currently, you have critical provisions that are passed in law that require that 2/3 majority. Currently, to achieve that 2/3 majority at the Senate, you must get at least one opposition. I hear people talking about the CRC report saying that it retains that when it comes to making changes to the entrenched provisions, like the Charter of Fundamental Rights and Freedoms, whether or not you're making certain changes, for example, to the Director of Public Prosecution, those are entrenched provisions. It will retain where you need at least one opposition senator, but work with me now. You have other mechanisms or other changes that will be made, or laws that will be passed, my apologies, that would need 2/3 majority. For example, extending the state of public emergency. That's not an entrenched provision issue now. That's something that already exists, and you're saying that when I call a state of public emergency, 2/3 majority vote to extend it beyond the 14 days will be needed. But work with me with the maths again. To get 2/3, which is roughly 67% of 27 senators, is 18. How much has said the government have now in the proposal? 15. How many the president have? 3. And how many the opposition have? 9. In other words, to attain 2/3, that is 18 of 27. So you can extend the state of public emergency, for example, without the opposition say. Why is that concerning? I need you to look at how this new head of state would now be elected. This new head of state, which is your non-executive president, the prime minister goes and consults with the leader of the opposition, and they arrive at some consensus. Then they take that name to the 2 houses of parliament, and they would vote separately in a secret ballot. And that is just reaffirming what the leader of the opposition and the prime minister agreed to. But say the opposition leader don't agree. You know what happens next? The 2 houses then vote by way of absolute majority. So in other words, simple majority vote. So you can have a head of state that the prime minister has installed. And if that head of state has the power to nominate 3 senators at the upper house, you ask yourself the question, are those 3 senators truly independent, or is there the possibility of those 3 senators ultimately acting on behalf of the ruling political party? Food for thought as we have the conversation.
Manley's first vice president, in that same meeting at that same time, went further. He argued that, and here I quote again, "In truth and in fact, a prime minister is a dictator for 5 years." Not my words again. The first vice president of the People's National Party, in commenting on Norman Manley's concern. An opposition member at that time, then Edward Seaga, later to become prime minister, strongly endorsed the first vice president of the PNP's view, and here's what Seaga said. Quotes, "Quite right. Only one minister must rule." And I would refer those of you who want to see more of that conversation to my own book that Michael referred to on page 169 and 170. The dictatorial powers referenced by the constitution makers, I want to expand because many of us may not be fully aware. I mentioned 4 of those powers. 1, to call a general election at any time that the Prime Minister considers it expedient to himself and to his party. Not necessarily good for the country, but expedient to himself and to his party, within the 5-year period that the Parliament has alive. This includes, ladies and gentlemen, the power to call a general election if the Prime Minister anticipates, as happens in parliamentary democracies, that the majority on his side would wish to change him for somebody else, a deputy or otherwise. It happened a number of times in the United Kingdom, Prime Minister May, Prime Minister Thatcher, they changed the leader, and the leader, former leader, would have to concur. In our context, in our constitution, if the Prime Minister apprehends that anybody else in his majority is going to move a vote of no confidence in him, alternatively, following that vote of no confidence, he can dissolve the entire Parliament instead of handing over, as the majority party would then wish, to his deputy or to someone else. So that is the first power we need to look at, and that was a big concern for Norman Manley. The second power, the Prime Minister can name as many members of Parliament as he wishes to the Cabinet. What this would mean, as it stands now, 40-odd members of the majority party could be named to the Cabinet. And what this does is officially and formally silence any criticism from the backbench, as it is called, of the parliamentary majority. Thirdly, the Prime Minister and the majority can amend clauses of our fundamental law, the Constitution, without any prior notice in respect of the ordinary clauses of the Constitution. And we saw that last week in relation to the clause that deals with the enacting clause of bills of Parliament. Government brought a bill. It was passed within a couple of hours, despite the abstention of the opposition and despite us, the people, having no notice of it. Completely legal, because this particular section of the Constitution is ordinary and not entrenched in any form, and subject to parliamentary majority. The fourth power I want to mention is that the Prime Minister, in effect, appoints the head of state. Now the Governor General, soon to be styled, if this process continues, the President. And we call it ceremonial, but let us be clear. It is the Governor General, soon to be the President, who has the authority to appoint on his own discretion the independent members of the Electoral Commission of Jamaica, the commissioners of the Integrity Commission, the public defender, the political ombudsman, and a number of other positions. So that ceremonial position, nevertheless, appointed by the Prime Minister, has the authority to make important changes in the structure. Over the years, both deliberations in and outside of Parliament, in the Constitution Commission of 1991 to 1994, in successive joint select committees of Parliament, in public representations, and various submissions, including agreements among different Prime Ministers. Agreements certainly from Prime Minister Seaga, Prime Minister Golding, Prime Minister Simpson-Miller, and Prime Minister Patterson. A number of measures were proposed, some agreed, to curb what they call dictatorial power in that Constitution-making committee deliberation. And I want to mention some of the measures proposed, some agreed. One, establish a fixed election date. So you and I don't have to wonder when they're going to call election. That's in the Constitution, for both general and local government elections. This was promised in the Jamaica Labour Party manifesto of 2011.
Within our first 100 days of government, we will start the legislative process to fix the date for general elections in Jamaica. So no government will be able to come and make false promises and hide the truth, trick you into voting for them, and then when them win, them throw on poison for you.
It was also promised by Prime Minister Holness to be done in the first 100 days following the 2016 election. We still don't have a fixed date. Second proposal, limit the number of terms a Prime Minister can serve. Third, limit the percentage, and Seaga was particularly supportive of this in his later years. In his earlier years, he was not, but in his later years, he became fully aware of the dangers, more so the perils, of having too dictatorial power concentrated in one person and in one office. And one of the proposals that he strongly supported and was agreed on in the Constitution Commission was to limit the percentage of MPs a Prime Minister can name to the Cabinet. Some can't name everybody and therefore muzzle everybody. Because once you're in the Cabinet, it means you have collective responsibility for whatever the Cabinet does, and therefore you have to go along with it when it comes to the Parliament. Thirdly, require concurrence by the opposition in the choice of the head of state. That was one of the proposals discussed and agreed on. Fourthly, and perhaps most significantly in my mind, it was agreed to provide for impeachment of public officials, including the Prime Minister, for misconduct. And here I quote from Jamaica's National Development Plan, Vision 2030, which came about after massive public consultation, public education across the length and breadth of the country. The National Development Plan, Vision 2030, states as follows. This is in 2009. Quotes, enactment of legislation for the impeachment and removal from office of public officials found guilty of misconduct, corruption, abuse of authority, or betrayal of the public trust. End of quotes. And that's page 124 of the National Development Plan. In giving effect to this agreement, on May 10, 2011, Prime Minister Bruce Golding stated in his budget speech in Parliament, and here I quote again, the bill to make provision for the impeachment of public officials has been completed and is to be submitted to the Legislation Committee for final review before being brought to Parliament. 2011.
Within the first 100 days of our government, we will start the legislative process to institute impeachment proceedings in Parliament. This will add another layer of protection of the Parliament to ensure that only members of unquestioned integrity sit in the Parliament.
We're now in 2024. Next, agreement to provide constitutional protection against parliamentary majority doing whatever it wishes to do, parliamentary majority manipulating, even abolishing independent bodies designed to check executive power, and Mike Hilton referred to that. To protect the Electoral Commission of Jamaica. That was said in 2006. Tomorrow morning, a parliamentary majority can abolish the Electoral Commission of Jamaica because it's not protected in the Constitution. Similarly, to protect the Office of the Political Ombudsman, that was passed in 2002. The Office of the Public Defender passed in 2000. Indicom passed in 2010. Each and all of those subject to parliamentary majority manipulation because they don't have constitutional protection. Once again, Prime Minister Golding indicated in his budget speech of 2011, quotation marks, the drafting of the bill to rectify this will shortly be tabled in Parliament, end of quotes. And finally, and very importantly, because this one was actually done and agreed and we now benefit from it, to place fundamental rights and freedoms, as Mike mentioned and Maziki, to place those rights and freedoms of the people beyond infringement of the executive or any organ of the state, except that could be demonstrably justified in a free and democratic society. And that's not for the Prime Minister to decide, only the courts can decide whether it is justified if our right to freedom of movement, freedom of speech is being infringed in a manner that is consistent with the Constitution. That fundamental rights and freedoms, let us note, was implemented following admirable public education and discussion, such as we're not having now. Public education, Dr. Lloyd Barnett wrote a simplified book that anybody could understand. Thousands of copies were circulated. so that people had a sense of what is in the Constitution and what needs to be done, ultimately leading to the Charter of Fundamental Rights and Freedoms. I conclude. The report of the current Constitutional Reform Committee of May 21, 2024, sisters and brothers, either ignores or rejects, in the context of grossly inadequate public education, grossly inadequate public consultation or explanation, they either ignore or reject these curbs on executive power, which our founding fathers, there were no women on that constitution-making committee, it's a point to note, which they said needed to be looked at in terms of the dictatorial powers of the Prime Minister. The dictatorial power of the Prime Minister remains, and with it, the inadequate ability of the people to hold the Prime Minister and the majority that he controls to account. This is completely unacceptable. Education around these issues, such as JFJ is doing, alongside meaningful consultation, must begin now. And decisions regarding these fundamental issues cannot be left to some indeterminate, unnamed second phase. We've been waiting on phases from 2006 for the Electoral Commission. This is not acceptable. There needs to be proper education, there needs to be proper consultation for us to respond, and not to take the report of the Constitution Committee as anything final, but simply a matter for us now to begin to discuss seriously. Thank you very much.